The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit, are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, we'll begin with Zetia Antitrust Litigation versus Merck. And Mr. Boutros, when you're ready, we'll hear from you.
Thank you very much, Your Honor, and good morning. May it please the court, Theodore Boutros on behalf of Merck and Glenmark. I'd like to reserve 5 minutes for rebuttal.
Indeed.
Thank you. At bottom, this appeal presents a fundamental question about class actions. Is this the type of case for which Rule 23 class actions were designed? The answer is clearly no. Class actions were not designed for a group of Fortune 500 companies asserting billion-dollar damage claims. Rather, class actions are meant to help the little guy to allow large groups of people with small claims to band together and sue as a class when it would not be economical for them to do so on their own. Here we have the exact opposite situation. The certified class has only 35 members, and the claims and damages are concentrated in 3 companies that have billions of dollars of claims and something like 97% of the purchases in this antitrust claim. The members are large, wealthy, sophisticated businesses with both the incentive and motivation to vigorously, directly litigate their substantial claims for billions of dollars. As the Supreme Court has declared, class actions are the exception, not the rule, and they are subject to stringent requirements which in practice exclude most claims. The claims here do not remotely qualify for class treatment. Right out of the box, the 35-member class fails Rule 23A's numerosity requirement, which requires a finding that the class is, quote, so numerous that joinder of all members is impracticable. And in making...
You know, I was obviously all counsel are familiar with the cases in the law, and this is in an area where it's a little murky. There's no absolute number one way or the other, but I think the ultimate test has 2 components that that I have considered, and one is the district judge exercised some discretion in this, and number 2, these 35 companies would come to court if proceeding as a group with probably an average of at least 5 people per defendant, which would be over 150, 200 people. And to try a case, I don't know, you guys been in big criminal cases, but I know most districts take big conspiracy cases and chop them down. It just gets impractical to have 200 lawyers and people in a courtroom and people making objections and hearing motions. And so as a practical matter, it's hard to say the district court abused its discretion in this number, which is in this gray area. A lot of cases have suggested as you get toward 20, maybe that works on an individual basis. And when you get above 40, maybe it's more presumptively too many. And this is in that type of range. But I think the bigger question is a practicality, just a physicality, practicality question. And I know both of you are experienced lawyers and probably recognize that. But the big question is, why did Judge Smith go off the deep end and saying the numerosity was okay? I just raised those. I haven't, sorry, but it seems to me that's sort of a very pragmatic issue.
It is, Your Honor, and you're going right to the practicability point, but the district court did not look at it that way. The district court said that sunk costs and future discovery costs made it judicial economy point towards class certification, which the Third Circuit in Modafinil squarely rejected. The district court had done the same thing there. The district court here made the legal error that the district court in Modafinil made by saying, well, there would be a lot of other individual suits, which is not the correct analysis under Rule 23A. You look to is it practicable? And it's very, very common. In fact, in Modafinil, once the case went back to the district court vacated class certification, and the case proceeded with joint plaintiffs. I think it was at least 12, and it's very common. I am involved in cases where there are joint defense groups with 40, 50 defendants, and everyone coordinates. This is an MDL. This very case is part of an MDL. And from a practical standpoint, the parties are very sophisticated. Companies like this are very experienced in joining together, sharing costs. That's what's been happening here, choosing one lawyer to be the lead on the main issues. So from a practical standpoint, this happens all the time. But the district court here didn't look at any of those issues. Instead said, well, there could be more. Yes, Your Honor.
Mr. Boutros, are you urging us to adopt the Third Circuit Modafinil test or not?
Yes, Your Honor. We think it's a very good test with the factors of judicial economy, which and practicality, incentive and motivation to litigate, which here these defendants or these plaintiffs have plenty of that. Financial resource, they have plenty of that, and geographical dispersion really has no effect. People are on this line right now from all over the country. The named plaintiffs in this case are not even from Virginia. So it's very easy for large groups individually to join together and litigate. And the class action device can be very, very, it can cut off individuals' rights, companies' rights, and defendants' rights. And there's just no reason for it here. This could be efficiently litigated, just as it was in Modafinil after the Third Circuit vacated the class certification. So yes, Judge Floyd, we think it's a good test.
I don't know, you may be aware, but in years past, I was on the Rules Committee, and we had a bunch of hearings on Rule 23 trying to explore revisions to it to solve existing problems. And one of the, it has taken on a life of its own, as we know, since 1966. But one of my questions really was, in this case, this is a very aggressive theory, antitrust theory in this case, and I gather that's before the district court on summary judgment issue. I have noticed, whether this is correct or not, and I'm not advocating this, but I've noticed a lot of large companies prefer the class action in order to obtain res judicata nationwide and put issues to rest. And this is the type of case that I really, as I read the thing, I wondered, why is Merck fighting the class action price? I would make it a worldwide class action and try to get peace. I mean, that's one of the claims that people thought it would serve from the other side of the coin. Now, that's a legal strategy, obviously, and it's not before us. But these things, I mean, the idea of trying to solve multiple litigations through MDL and class actions is always a very highly discretionary problem. And I know the Supreme Court has not been a fan of class actions in any, if you look at its cases over the period of time. But well, enough said. I hear you.
No, and you are, but you make a good point here. There would be res judicata if we had joinder. And we think there's no reason why these companies can't be joined together and resolve all these claims in one case. And it is very, from a practical standpoint.
Well, what's your advantage to have a courtroom full of 200 people as opposed to 25 people you now have, or whatever it is?
Well, I think, Your Honor, it wouldn't have to be 200 people. I think we would have summary judgment. We would have litigation and where we'd coordinate among the plaintiffs would coordinate among themselves to respond. They've been doing a very good job of coordinating so far. You know, there are other components of the MDL. So there would be res judicata. The class action mechanism can, as this court's aware, have hydraulic pressure to settle when there are billions of dollars at stake in the class. That's the game here, and that sort of brings me to the bizarre situation. It's
the
like
old Greenmail argument, isn't it? That
yes,
the risk is too high.
Exactly. And that's one of the reasons 23F was added to the rules, to allow parties to come to appeal before that pressure occurs. And here, if something's rotten in Denmark, something's wrong here, where you have these three major companies with billions of dollars of claims, just like in Modafinil, sitting on the sidelines, and then our three plaintiffs are, I'll put it charitably, a motley crew. They're not adequate. They're not appropriate representatives. One is a litigation vehicle formed by plaintiffs' counsel. It's a shell corporation that and it's run by a good friend of one of the plaintiff's lawyers. One is a bankrupt felon that entered a deferred prosecution agreement and then defaulted on its fine to the U.S. government and went bankrupt, and it owes the defendants, Merck and Glenmark, millions of dollars. So it has fiduciary duties to both the class it would have and to the defendants. And then the third, Castillo, didn't even buy the generic for 2 years after the generics came on the market, and didn't buy it until after this lawsuit. So it was seeking pretty clearly to attempt to manufacture standing. So that group is not appropriate to litigate this on behalf of a class of absent class members. So it really turns the class action mechanism on its head. It's not what class action device was meant to foster, where you'd have small individuals, the little guy, banding together where their claims wouldn't be worth it to go alone. That's just not what we have here. And so I think the district court, even Judge Niemeyer, with the approach you're taking, practicality, could we do this? I think we could, with so much done remotely in these large cases. About 90% right now, about 100% is done remotely. It's very efficient. There would be a res judicata effect if we prevail. We do think, Judge Niemeyer, you put your finger on something. These reverse payment claims have gone off the rails. It's really interfering with the statutory scheme.
I do want to get into that a little bit because there's some issue here about typicality and predominance related to injury, and you've made various arguments in that regard, which raises the antitrust theory. What is the antitrust theory? And these cases involving the misuse of patents or extending patent monopolies are dicey. And in this one, it's if I understand correctly, and I'll check this out with Mr. Sobel when I talk with him, but if I understand correctly, the injury has to suppose that the patent is invalid, because otherwise anything that occurred before expiration of the patent, a patent holder is entitled to charge super competitive prices and has exclusive use of the patent, and it's very strange, and they can license it. There's a broad range of conduct that is appropriate, and I'm not sure that the agreement as written in this case was a violation of the patent. Now there is a lot of side comments as to the way people try to construe it, but or attempt to construe it, but it seems to me to presume the need for competitiveness going back to 2010 or 2014 or 2012, whatever date you're picking, means that there's no patent exclusivity at that point. And that's a hard theory to carry because it basically presumes a patent's invalid.
And Your Honor, exactly. And we also have the problem that they want to prove by averages, even though we know who the 35 plaintiffs are.
Well, that's not hard to do. I mean, if there should have been competition in 2012, there's no patent validity, then all you have to do is establish have a market price established, and the differential between what was actually charged and the market price is the antitrust damage calculation. I mean, there would be damage injury if you had super competitive prices.
Here, Your Honor, though, it's different because the theory is that if a generic had gone on the market earlier, and they have some speculative theory that it would have gone on much earlier, that the plaintiffs would have bought the generic and that the prices would have been lower. But here, our experts put on.
When you say earlier, you mean before the end of the patent?
Yeah, once the agreement, under the normal rules, they claim that this agreement caused the generic to be delayed. And so
that's to me is the rub of the issue, because the theory there is there's an extension of the monopoly beyond the patent term. In other words, that the delay in competition has some effect on competition after the expiration of the patent. But I don't understand the theory fully, and Mr. Sobel will explain it to me, I'm sure. of why we're going back before the expiration of the patent and saying that there should have been a competitive situation at that point when the patent gives Merck exclusivity.
It's a very sketchy theory, Your Honor, and
Well, the
they've got
sketchy theory, it's invalid. That's what they're saying, basically. And then the threat to its validity entered into the license agreement or the agreement. And the argument was that there was some compensation paid,
another judge had rejected that theory already. And so here the problem, and maybe I'll reserve my time, but here we know some of the plaintiffs did not go into the market, would not have gone based on their own conduct. So we don't need hypotheticals. And this court in Broussard said, averages, including an antitrust, can't mask the lack of injury in addition to the reasons you're pointing to, Your Honor.
Yeah, but see, the injury, I'm not sure the timing of a purchase makes a bunch of difference. The question is whether Merck had the monopoly power, had the market power to charge super competitive prices. Anybody buying a super competitive price where competition has been hurt, that's antitrust injury. And it doesn't matter whether they waited to buy or delayed to buy. If they bought above what would have been a competitive price, it seems to me there's damage, isn't there?
Well, I think here that, that in the generic versus brand market, there are different reasons why a plaintiff would continue to buy the brand as opposed to switching to the generic, just for competitive reasons. Here, we have to look at, as part of the inquiry, what did the party actually do? And so if you just look at Castillo and there are other plaintiffs, and Merck had a strategy for marketing where negotiating, much like the Third Circuit's Lactamol case. So you cannot just make this broad assumption that plaintiffs would have gone into the generic market. Castillo didn't. So there are all kinds of problems as to whether at least 7 of the plaintiffs had any injury on top of the issues that Your Honor is raising. With that, I'll reserve the rest of my time.
Yeah. All right.
Thank you.
I'm sorry, I preempted. Did any Judge Floyd or Judge Rushing, did you have anything further, Mr. Lucas, at this time?
No, sir.
Why don't we hear from Mr. Sobel, and then we can come back. There's a rebuttal time. Mr. Sobel?
Good morning, and may it please the court. Thomas Sobel, Huggins, Berman, Sobel, Shapiro for the direct purchaser class and the plaintiffs. Perhaps, Your Honor, it probably made sense for me first to address this substantive law issue. Even though it's not directly before the court, you asked some questions about it. So
I was asking it basically to see about the injury. There was some argument that because of the nature of injury and damages, and I guess you guys are making a distinction between antitrust injury and the damages to the individual plaintiffs, because antitrust injury would seem to be common to the whole group.
Yes,
whereas the damages might not. So I was trying to figure out where the antitrust injury was and what's needed to prove. And I had a little trouble with your theory on all the conduct you're alleging before the expiration of the patent.
Sure. Okay. So let me address that then, Your Honor. It rests on the Supreme Court's decision in Actavis, 2013.
We're familiar with that, yes.
All right. So essentially what the court in Actavis ruled is following. In a Hatch-Waxman patent dispute, the position of the brand company is that I've got a valid and infringed patent. You should have to stay out of the market until my patent expires. That's the brand's position. The generic's position in that litigation is no. We don't infringe the patent, or your patent's invalid, or both. We should be allowed to enter the market now. And there's no money at stake between the two. And so when they settle that litigation, and they can do so lawfully, they, on the basis of the merits of the patent dispute, the probabilistic nature of the patent dispute, the parties reach an agreement somewhere between the time of their agreement and patent expiry, somebody in between there, the agreed entry date. What the Supreme Court in Actavis said was, well, wait a second. If in a dispute like that, we see a reverse payment In other words, we see the brand company, in addition to agreeing to an agreed entry date, we see the brand company making a payment to the generic. Then that's probably going to be in exchange for moving that agreed entry date later. And the Supreme Court in Actavis has held explicitly that patents may or may not be valid. They may or may not be infringed. It's probabilistic, and that the consumers are entitled to the benefit of that those probabilities. If you influence settlements with payoffs, agreed entry dates will be later and consumers will injure. And so that's the basic theory right from the Supreme Court. The circuit courts have, of course, then embraced this notion that if a payment from the brand...
Let me ask you this. Under your theory, do you have to establish as part of your case the invalidity of the Merck patent?
For purposes of showing, the answer is twofold, Your Honor. For purposes of showing that the companies violated the antitrust laws by entering into an unlawful agreement, we do not need to prove anything about the patent merits whatsoever. In fact, the Supreme Court, that's also directly from that Actavis case. Now, however, when I'm trying to prove when that date otherwise would have been for causation, so if I take the reverse payment out of that agreement, and now I'm trying to figure out where would parties have negotiated on the merits of the patent litigation for causation, under most of my theories, I put evidence before the court regarding our view about what those patent merits were. So it does influence its way there, but again, it's probabilistic. There's no yes or no being decided about whether it is valid or isn't valid, fringed or infringed. Instead, it's a probabilistic evidentiary proffer to be able to determine when rational, law-abiding companies not paying each other off would have agreed to an entry date.
All right, I didn't want to take you off too far off the main course because on this appeal, I guess Judge Smith has all that before her, but on this appeal, we're really just on a 23F review of the certification.
Yeah. So, of course, the beginning of the analysis, of course, is that if one looks at this record, we see that the defendants are challenging discretionary decisions by two experienced, thoughtful jurists, Magistrate Judge Miller and Senior Judge, District Judge Smith. And they, in a 96-page report and recommendation and an equally thoughtful order by Judge Smith, they painstakingly go through all of these issues. Now, let me just take as an example the numerosity issue and the practicality. This case is complex. It's unbelievably complex, as you can just tell by the nature of what I was just indicating. We'll have patent evidence, we'll have economic evidence, there'll be evidence about cardiology, about when FDA makes certain approvals. And the district court, when looking at this case, said essentially, wait a second, this is complicated enough. If we have 32 more plaintiffs in this case, that's not practical. We don't think, because the joinder analysis under the numerosity, at least when you're looking at judicial economy, assumes, let's just assume for a moment that they all will be joined, or virtually all of them will be joined. Imagine the complexity that that would add. And it's not just lawyers, although it is lawyers. These judges know this already because there are a small group of retailers who have filed ancillary, parallel cases with us. They are separate cases, but they're in the same proceeding with us. They've got their own separate lawyers. They've argued different 12b6 issues. They've got their own economist that's opining on 3 issues overlapping with my class. Imagine if you do that 32 more times. No, it's completely impractical.
Mr. Sobel, can I ask you about that point? The magistrate judge and the district court both, I think, noted that there wasn't much evidence about pooling resources for joinder, that these expert fees and all of, you're right, it's a complex case. but there's reason to think that not each plaintiff would have, their own expert or their own evidence on this point, but they would work together in the way that they have so far. But the courts, in analyzing that question, said, the direct purchasers haven't analyzed whether there would be sort of economies of joinder here. So I find that this factor weighs only slightly in favor of class certification. Why is that the right way to think about the factor? If the question is joinder impracticable, and you bear the burden on that?
Certainly, Your Honor. So I think that the record before the district court shows that the district court saw some aspects of numerosity strongly favoring the class and others only slightly favoring the class. The factors that the court saw strongly influencing class was this practicality issue. Indeed, I think the report and recommendation explicitly talked about how you can anticipate that there will be more lawyers, that there will be more discovery disputes that will burden the court unnecessarily. So I think on that factor, I think the district court was fairly clear that the evidence more than was adequate. On the other prong that I think that you're referring to, Your Honor, where the court found it only slightly favoring class, is whether or not we're going to see other class members, whether they were or are or are not going to be able to file, and in terms of whether or not they had the ability. Now, there is evidence that was before the district court, and it did weigh in our favor, and the district court found in our favor that as a practical matter, more than half of our class has negative value claims, meaning that anything that they've asked for, it does not even make up for the amount of costs that it would take to fund the economists, all of the experts. And yes, I think, Your Honor, that they're then trying to say, well, how much more evidence would one need in that particular situation? I think that we made the showing. The district court said that we made the showing. It wasn't completely bowled over by it, to be sure, I acknowledge, but it did rule in our favor on that aspect.
Well, the court said that there wasn't irrelevant evidence, which was what would there be sharing of these costs and things in joiner? And the court said, presumably there would be, but I don't have evidence about that. So I'm only going to count this slightly in your favor, rather than saying you bear the burden, you didn't put evidence on this. So, that weighs in the analysis differently.
Yes, no, I think that's exactly right, Your Honor. And there is not that kind of evidence in the record. Of course, I will, in fairness to myself, with all respect, Your Honor, suggest that how would one put that kind of evidence in? I would need to speak to the 32 unnamed class members, have a hypothetical discussion with them about whether they'd be willing to join. If some of them, because we know from history that only some of them do, most of them don't, have the hypothetical question, well, would you be willing to share experts? Would you be willing to do this? In other words, case-specific evidence about what you see happens in the future under a hypothetical situation is quite difficult to do in this situation. We did produce to the court, however, evidence from what's happened as a matter of historic fact in other cases. So we know as a matter of historic fact that when the modafinil case was decertified, that most of the, at least half of the, I'm getting two cases confused. I don't want to misstate something. A third of the class in the provisional case did not file any case at all and was left out of the proceedings, even though it was a case that had already recovered significant dollars for the class. And in androgel, we know that half of the class did not join once the case was decertified. So we do know as a practical matter what's happened there. And we also know in terms of the sharing experts, that kind of thing, that in this case, that there are retailers, but they are not sharing all the experts. That is it, and it does require more work just for one group of retailers to come forward with their own economists, which they have their own Daubert motions on, and they have their own theories as to how to prove market power.
And is that the group just to make sure I'm tracking with you, the retailers have already expressed that they would not join, they would opt out of a class, so they're not counted in this 35 class members. Is that right?
That's right, Your Honor. That's the group that I'm talking about. Okay. And so even in a situation where you have the highest probability of trying to have people work together, which is this subgroup of 7 wants to litigate by way of joinder, even they are not sharing all the experts. Even they are presenting different 12b6 issues for the court to have to rule upon. And that's just one example of one group. And that's why I think that the district court was acting well within its discretion to be able to be saying, no, it's going to be completely impractical if we're trying to have 32 more plaintiffs joined in this action. I also want to just address briefly this averages argument that has been raised. In this case, there is no reliance on averages for the kind of problem that averages can give rise to. So averages, if you're trying to use averages to be able to prove that there's some average change and that average change therefore has an effect on everybody, the question is, well, okay, what is that average change in relationship to in terms of the harm that you're trying to show? Here in this case, we know by looking at the defendant's own records, looking at each class member, what happens. And what Magistrate Judge Miller and Judge Smith observed in their detailed findings is that of the 35 class members, 30 of them, when the generic became available, bought the generic and bought the brand after that period of time. And of those 30, 29 of them substituted to the generic. And in every time of those 29, 100% of them paid less for the generic. In other words, we know when you shift from the brand to the generic, you definitely pay less. And that the vast majority, 98% of class members buy the generic when it became available. So here below, the defendants really only raised 2 issues. They said, well, 3 brand companies only bought the brand and they never bought the generic. Well, we say, and the magistrate judge and Judge Miller said, but that's because these 3 brand companies weren't buying this drug at all by the time the generic became available. And we know from your own records that 98% of the class members will buy the generic if it's available. So that's not an average, and that's a logical inference that these jurists were entitled to make. And then for 6 other small amount of purchasers, the defendants argued, well, this group of folks, they didn't buy an awful lot of the generic when it became available, so we don't know about them. But again, it's not the amount that you buy, it's whether you would have had any amount of injury at all. And again, I think that these jurists were well within their discretion to make the findings they did in that regard. Really, this whole averages argument that the defendants have made was an afterthought. Their opening opposition brief spent 1 page of text on the issue of predominance and never used the word average. This only came up after the record was set up when the Lamictal decision came down, and the defendants since have been trying to jump on that as if it's a bandwagon, but the report recommendation and the decision here both explicitly took up whether Lamictal applied, how it does not apply to these circumstances, because this is not an averages case. I'll also say the same thing then going back to the modafinil case, and Judge Floyd asked my colleague whether or not that test should be employed here. What I'll also say about that case, Your Honor, is this. First, again, Judge Miller and Judge Smith, being careful as they are, explicitly take up modafinil, decide and follow its holdings to make sure that if this court were to follow everything religiously about what would happen in that case, whether or not this class would be sustained, and they rule that it does not overcome the issues. What I will say in particular about modafinil is modafinil said that there are two considerations that are primary on the numerosity prong. One is judicial economy, and then the second is whether or not you can whether the class members have the ability to come into the market. On judicial economy, the modafinil also said, if you've got judicial economy and there's some inability of some of the class members not to be joined, why would you not certify the class? Of course you would certify the class. The other issue in modafinil was then the ability of the class members to bring their own case. And really the defendant's argument boils down, as even their beginning introduction here, is that they find offensive in some way the fact that the class includes 3 national wholesalers. Well, let me first, the real question should not be whether they're in there, but rather if you deny certification, who's going to be left out? And so let me just make sure that these 3 points about are clear. First, in the United States, most people when they go to their local pharmacy and they buy drugs, they're buying drugs that made their way to the pharmacy through the so-called retail channel distribution. That marketplace, that distribution has over the years become more and more consolidated. It does have 3 national wholesalers, but it also has 3 score or more smaller wholesalers scattered throughout the United States that also distribute the drugs. In the United States, also under federal law, when a brand company overcharges for the brand product by violating the antitrust laws, the parties that can recover are the direct purchasers. So in the United States, you're going to see this marketplace of these distributors coming to the fore to bring the cases. So it ought not be a surprise then that 21 district courts have certified this class with the same makeup, and 2 circuit courts have affirmed these classes, all of those cited in our brief. So why do I not find offensive then having these 3 big wholesalers in the class? Well, first, it's not what is important to think about. The question really is, we want to make sure that the smaller claims are in the class. And the other thing too, by the way, is these big 3 wholesalers, they pay their fair share. They're not free riding. If there's a recovery, they have to pay their fair share of the expenses and the attorney's fees. If there's a defense verdict, they're out of luck. So they're paying their fair share. And finally, I'll just say that the Supreme Court in Amkin, cited in our brief, said that there's nothing in the rules that has, for class certification, that finds offensive having class members with large claims. And I think that point, bottom line, is that the Supreme Court has already rejected the fundamental premise of the defendant's arguments in this case. There's no questions, I'm done.
Thank you, Mr. Sobel. Mr. Boutrous? I think you're moot. I can't hear you.
How's that, Your Honor?
Fine.
Thank you. And so Mr. Sobel is pressing a position that's directly at odds with modafinil. The facts were exactly the same. It was a reverse payment class action. The same situation. The 3 big companies had the majority of the claims. The district courts made the exact errors. They misapplied. They made exactly the errors. They considered would there be more individual suits. Modafinil said that's not proper. The question is practicability. With respect to discovery, will there be future discovery? That was exactly the issue. So they're pushing for a circuit split. If this court finds there is numerosity, then we have a circuit split. There's no reason to create that kind of split. Secondly, Judge Rushing was making the point that the burden under Dukes versus Walmart and other cases, plaintiffs have to prove that there is grounds for certification on each element, including numerosity, by a preponderance of the evidence. They can't just speculate. They can't just speculate that people wouldn't join the case individually. They have to provide evidence. And as the district court and the magistrate judge found, they didn't provide evidence. They provided a declaration, I think, from Mr. Sobel that just assumed and speculated that all the plaintiffs would hire their own experts when we know that's not true. Mr. Sobel mentions the retailer class. The retailers have been joining with the direct purchasers and the end purchasers to hire the same experts to oppose summary judgment motions. So the facts here support our theory. Nobody's going to go have 150 lawyers doing the same things over and over. And the question here, they didn't put any evidence in on that, Your Honors, that they had a burden to prove that people wouldn't join in if there were joinder as opposed to a class. And as the district court and magistrate judge found, they didn't put in any evidence. They claimed there might be retaliation. They didn't put any evidence that anyone was concerned about retaliation. And in fact, here there's no evidence in modafinil. Mr. Sobel suggested it would be impossible to demonstrate these things. No, parties put in declarations. They say we couldn't do this. It wouldn't be practicable. So they're pushing for a position that would directly contradict the Third Circuit, that directly contradicts Dukes in terms of not putting on evidence. The district court was supposed to engage in rigorous analysis to see if they had demonstrated numerosity and these other factors, and they just simply put in no evidence. And the question isn't would each of the parties, the class members here, join an individual action as joinder. The question is whether it would be impracticable. And there's no evidence that it would be impracticable. There's no evidence that it would be impracticable to hire the same expert. They hired one expert here. They already have the expert. Mr. Sobel assumed he knows better than this. Not every party is going to hire a different expert and pay them $3 million. That's absurd. And so the class actions are meant to foster efficiency and fairness at the same time. There's no reason to struggle to allow these sketchy named plaintiffs who each have major problems to represent everybody else when it would be perfectly practicable to have an individual action where parties could decide whether or not to join the class action. And Mr. Sobel suggests, well, one party, and there's no evidence, as the district court found, that any party would not join. It's very easy to join. If Mr. Sobel continues to litigate for one of these plaintiffs, the others would file a joinder and make their choices. The district court did not find, Judge Neumeyer, that the courtroom would be filled with lawyers and it would be hard to manage. And the district court did not find that it would be difficult for parties from different places around the country. And in fact, none of the named plaintiffs here are from Virginia. Everyone's doing things remotely. It's very efficient.
Mr. Chris, can I
yes, Your Honor.
Ask you about this question about who would join? The district court called it a high standard under A1 and said that you have to show impracticality of that all could be joined. And I've been trying to sort out what the court meant by that, what sort of interpretation was going on there. Obviously, the burden's not on you to show that everyone would join, but the court seemed to be emphasizing the all there and saying that was important in the analysis. And I wondered what your thoughts were on that, if the parties had argued about that in the district court or what was going on there.
Your Honor, I think it is one of the core legal errors the district court committed. The analysis went something like this, that since Rule 23A says, is it impracticable for all to join? If there was some theory that maybe someone had a negative value claim, which was the plaintiff's argument, then that meant it was impracticable for all to join. That's an incorrect legal analysis. And there's no evidence, as the district court itself found, that plaintiffs offered little evidence that class members would not join the suit on their own if it was individually. And so think about that I think they had 4 claimants who had claims under $300,000. It was a very small group. Their claim is that, well, if we just assume with no evidence that they wouldn't join individually and there's no evidence, then that's enough to certify a class. That has it completely backwards. And I think, Your Honor, that goes to the just core error of the case. And again, I'll finish with this. I think modafinil has a straightforward framework. The district court and the magistrate judge made the exact errors that the district court in modafinil made when the create a circuit split unnecessarily. And this case can, in a very practicable way, be litigated with joinder as opposed to the class action, which is the exception, not the rule. And I thank you all for your time.
All right, thank you. As you know, the custom of the Fourth Circuit, and I think it's only the Fourth Circuit, is to come off the bench and shake your hands and tell you how great your arguments were and appreciate them. And the best we can do is to say that now, and we do appreciate your arguments. And sometime you'll come back. I think Mr. Bouchis has been before a few times. I can't remember if you've been before, Mr. Sobel.
No, but it's been a pleasure, even though it's virtual.
Anyway, yeah. Anyway, it's good to have you here. Welcome to the Fourth, and we'll go ahead and proceed on to the next case.
Look forward to seeing you in person. Thank you, Your Honors.
All right, Ms. Hashimoto, can you hear me?
Yes, Your Honor.
And Ms. Khan, can you hear me?
Yes, Your Honor.
And Ms. Kalin?
Yes, Your Honor.
All right, we're all on board. We'll hear the case of Desper versus Clark. And Ms. Hashimoto, I suppose you're going to make an introduction, and we look forward to that.
Yes, Your Honor. Thank you. My name is Erica Hashimoto, and I am court-appointed counsel for Mr. Desper. A third-year law student, Manahil Khan from the Georgetown Law Center, will be arguing on Mr. Desper's behalf with the court's permission.
Yes, of course, and thank you very much. And Ms. Khan, you may proceed.
Your Honor. May it please the court. The central dispute in this case is whether VDOC officials can indefinitely deny visitation between a father and a teenage daughter who wishes to see him, all for, in VDOC's own words, no specific reason. From 2009 to 2015, VDOC officials regularly facilitated visitation between Mr. Desper and KD, his minor daughter.
Can I ask a foundational question before we get too deep into it? There's a fairly extensive regulation in place, and the regulation provides a mechanism for evaluating visitation rights in such circumstances. And it includes, importantly, a psychological or medical review in the process. And the question I have is whether you're challenging the regulation in this case. Are you saying the regulation itself is unconstitutional?
No, we're not, Your Honor. Mr. Desper is alleging that the regulation was arbitrarily applied to him.
All right, so now the question is, where did the defendant, the state, go wrong in applying the regulation? It looks to me, from what I can tell from what's been alleged, it looks to me that the process was followed. The unfortunate part was they weren't very responsive to him in telling him what happened. They sent an email to the mother, but they didn't tell him what happened. But we do have a look-peek, which is not necessary for a 12v6, but we do have a look-peek on the summary judgment side, where the state said that the reasons are medical and it's in his file and he can look at that file at any time. So my question is, where did the state go wrong in applying its regulation?
Your Honor, at the 12b6 stage, we don't have a justification from the state as to how they've applied the regulation to Mr. Desper. Yes, there might be things in the summary judgment motion, but the district court didn't rule on that.
Isn't the burden on you? Isn't the burden on you? I mean, yeah, the complaint alleges, really doesn't allege, it basically alleges he doesn't know why he was turned down, but that doesn't amount to saying they violated the Constitution.
Respectfully, Your Honor, the complaint alleges that there was an arbitrary denial. This was a father and a daughter that had visitation regularly for 6 years, both before and after the regulation
Well, I
was
understand
amended.
that, but now you're challenging the regulation. The regulation basically, persons who have been sexual predators, and in this case, we had a 16-year-old that was a victim, and the description that Mr. Desper gave in his application about the former conduct was very callous. It showed, I mean, he says we were just fooling around. Well, you look at the conduct, and it was more than just fooling around. It was quite violative. And with respect to the rape, because taking advantage, he comes back and says, well, she had a better GPA than I did. And so that case, I'm not guilty in that case. So the medical examiner surely asked questions. We don't know what the questions asked, but surely asked questions of him and concluded that they're not satisfied it would be safe. Or didn't satisfy the regulation. They have a discretionary right to make that judgment call. But you have the burden of showing that what they did was unconstitutional, and because you don't know the reason, you assume it's unconstitutional. I think that's where I have to end up, it seems to me, unless you can demonstrate something in the complaint that shows otherwise.
Your Honor, I have two responses to that. The first is that the regulation itself contemplates someone with Mr. Desper's criminal history being able to have visitation, and was given visitation for 6 years, both before and after the regulation, and regular visitation. Moreover, courts evaluate these types of claims on summary judgment. The Supreme Court in Overton made clear that visitation restrictions need to be challenged under the four-part Turner analysis, and there the court looked at a whole trial record worth of testimony and decided that those regulations were reasonable. Your Honor is absolutely correct that we don't know what the state said in those regulations. We don't know why they're denying visitation. What we do have on the record is that a VDOC official has said that there's no specific reason that they're denying. They gave visitation in the past. Moreover, Your Honor, what goes to the scope of the arbitrariness in this case is the broad depth of the visitation that's being deprived. We're not just talking about in-person visitations. It's contact visitation, non-contact visitation, video visitation. The state has made no justification as to how.
None of this has been alleged. I mean, you're suggesting that now visitation could be limited to non-contact. A lot of these prisons in Virginia, they have big rooms with tables at them, and the guards are watching and walking around, but the visitors come in and sit at the table with the prisoner and they talk, and when the time is up, they leave. But they're face to face, and they're in the presence of them, and that isn't being addressed, and that isn't alleged. He alleges that I was formally allowed to visit, and now I'm not, and I wasn't given a reason. That's really what his complaint is, isn't it?
No, Your Honor. He's made clear that he alleged that there was a deprivation of visitation without legitimate justification. The state doesn't dispute that video visitation is available at their facilities and at the one that Mr. Desper is currently at. So is non-contact visitation. He included the regulations. The district court had before it all the options, as this court does now, but the depth of the bans of visitation without giving any reason as to why the government's justifications are served is a wide sweeping ban, Your Honor. To suggest that Mr. Desper can't even bring a claim would violate what the Supreme Court set out in Overton, and that was to evaluate the scope of prisoners or incarcerated parents' constitutional rights and the scope of an infringement on a developed record.
Why hasn't Mr. Desper gone to look at his medical file and see what's laid out in there? He filed a motion for summary judgment in this case, and in response to his motion for summary judgment, the state came in and pointed out that the medical reasons are in his medical file and that he has access to it at any time. That's on his summary judgment motion. You would think as soon as he received that, he would go and look if he wanted to know what the reason was.
Your Honor, the state didn't. He alleged that there was an arbitrary ban. The state didn't serve him. We don't know what
I understand. We're looking at the 12b-6. That's all we're looking at. But my question is, you suggest that he's being arbitrarily treated, and it looks to me like they went through all the 4 steps that the regulations provide. And in addition, he has been provided information in his summary judgment process that says he can look at his medical file at any time.
Your Honor,
that's a HIPAA violation for anybody else to go in.
Your Honor, it was his own medical information, as he noted in his objections to sealing. But moreover, Your Honor, this issue hasn't been decided on summary judgment. That's not on the record. That's not what the district court made its decision. The dispute before this court is whether an incarcerated parent states a valid claim when he alleges that prison officials have arbitrarily and indefinitely denied visitation. And
Ms. Khan, as to your equal protection claim, why wasn't your client able to name specific individuals who had been similarly, who were similarly situated?
Your Honor, Your Honor, Mr. Desper's case is one where the state has all of the information. To be able to show a class of similarly situated people, he needs access to more information about how the state is classifying a particular parent's criminal history, their mental health evaluation. All of this information is in the state's hands, and Mr. Desper has no access. All he can do at the 12b-6 is make these allegations. He needs access to discovery to be able to prove his allegations. We don't know why we have these mental health evaluations, but
if he has no information, why is his claim plausible? In other words, he has to allege a plausible claim, and lawsuits are not intended to be just hollow allegations with the hope the discovery will reveal the claim. He has to have a plausible claim, and maybe he should have at least one person or other person he thinks might be in the same situation. Of course, the state did answer that in its affidavit. That's, as you point out, that's not part of the consideration under a 12b-6, but it is in the file, and this is not a case of enormous unfairness. It's a case of his lack of knowledge. Apparently, he didn't even know his mother got the email about the denial, I don't think, but.
Your Honor, he certainly, yes, he does need to state a plausible claim, and he has. The Supreme Court in Overton has made clear that family visitation restrictions that are arbitrary are different. He's plausibly alleged arbitrariness. Here, he said that there was not only 6 years of visitation. We have an allegation that there was for no specific reason, but the way that the state has dealt with implementing the regulation to him has been arbitrary. Your Honor, all we have on the record is, even the summary judgment record, is these sealed mental health evaluations, but that individual didn't make the decision. The committee made the decision. We have no idea what they considered. We don't know how much deference they put to that mental health evaluation. All we have is these documents that were filed under seal, and Mr. Desper needs discovery to be able to prove that. We need to know what actual reasons the committee gave, how that process was implemented. This court, in the due process context, in Akuma and Smith, has warned against prisons not giving a furnished factual basis or providing a meaningful opportunity for recovery into accessing visitation here. All we know is that they haven't given a reason. And to go back to the dispute of this case, Your Honor, all we're looking at is whether parents like Mr. Desper can bring a claim. And to suggest that they can't, Your Honor, would be to say that prison officials can restrict any type of visitation for as long as they please without ever giving a reason or saying it's because we don't like you. And that parent would have no protection to be able to challenge such a claim. Mr. Desper's, the contours of his rights are something that the district court can continue to address in summary judgment motions. Once we have all the facts, they can look at what other types of visitation would be available, what alternatives are available to him, the impact that visitation would have. These are all really important steps of the Turner analysis, but this court can't evaluate them because the only information we have on the record is limited. And the Supreme Court has made clear in Overton that the district court should evaluate and make factual basis on at least the final three Turner factors and parts of the first Turner factor as well, Your Honor. If the court has no further questions, I'll reserve my remaining time for rebuttal.
Okay, that's fine. We'll hear you on rebuttal. Ms. Callan?
Good morning, Your Honors, and may it please the court, Michelle Callan for appellees. If the last year and a half has taught us anything, it's that in-person social interactions are both valuable, but at times must be avoided to protect others. At issue here—
You know, that's all understandable, and I suspect, reading between the lines, this would probably prove to be a difficult case for Mr. Desper to bring in view of the history and his attitude to these things. But why wouldn't the prison send him a short email or note saying, we have denied your application, you can apply again next year?
I think certainly that's a best practice
No, I think it's a lousy practice. In other words, his whole disappointment here is he kept calling to find out what happened and what the reasons were. And it seems to me the prison authorities could create a lot of peace and legitimacy for its process by simply letting him know that on a more formal basis than letting it all come through his mother or having him go look at the medical record or whatever it is. It seems to me that he's made an application for visitation rights under the red thing. He alleged it went through the process. He was examined twice by two different medical examiners, and he had two different evaluators, and this was all followed. Decision was made, but they didn't send him anything. That it seems to me, if it's nothing else, it's a courtesy. And it would be very productive, it seems to me, to prison harmony to have that practice followed through. It's not in the regulation, but if anything else, that troubles me about the case.
Certainly, Your Honor, and so the question then on at this point is whether that lack of courtesy rises to a level of a constitutional violation. And that's really the crux of the issue here. And it simply, as a legal matter, does not rise to the level of a constitutional violation.
Ms. Callan, in the sum of your opponent's argument was there is a clear need for discovery, and we do have an adequacy of process rule. Why should we affirm the district court at this stage based on that need?
Certainly, Your Honor. I think because even the face of the complaint and the documents appended thereto show a reasonable basis for denying Mr. Desper visitation here. As Judge Niemeyer pointed out, the documents appended to the complaint show that Mr. Desper has failed to take responsibility for his action in connection with both sex offenses at issue here. The one that placed him on the registry in the first place, where he represents that he was just playing around rather than taking accountability for the sexual offense against a 16-year-old in that case. And likewise on the rape conviction for which he's currently serving his time, he likewise has not taken responsibility. So looking at the complaint itself and the documents appended thereto, they themselves support the decision in this case to not grant permission for in-person visitation. We certainly recognize that this policy, like many prison policies, seeks to balance multiple competing interests. And those include the safety of visitors, especially minor children, interests of inmates in safely seeing loved ones, assuring that sex offenders are not placed in tempting situations in which they might harm minor children, the safety of other inmates, threats to prison officials, and efforts to further penological goals generally. Given the various interests at stake, the Supreme Court emphasized in Overton that courts should accord substantial deference to the professional judgment of prison administrators who bear significant responsibility for defending the legitimate goals of a correction system and for determining the appropriate means for accomplishing them. The Supreme Court in Overton also made clear that the burden is not on the state to prove the validity of the prison regulations, but on the prisoner to disprove it.
Well, she's conceded, and it seems to me the complaint doesn't challenge the regulation. I think what's challenged, it seems to me at the heart of the complaint here, is he thinks they made a wrong decision because he thinks he should get visitation. But his biggest complaint is he doesn't know why they turned it down. They didn't give him any explanation. So we're not, I don't think we're challenging the regulation. I think, and it's hard to say we can challenge substantively the decision, although on his complaint, the face of his complaint, there seems to be a justification for denying visitation rights, if at least on a temporary basis. But I get back to the fact that with such a fulsome regulation and all the steps and evaluators involved and decisions that are made, it would hardly be, it seems to me, it would hardly be burdensome on the state to send him an email or a message saying his application's been denied. We haven't seen enough improvement and apply again next year.
Certainly, Your Honor, we don't contest that, but what we do contest is that the failure to provide that notification, that rises to a level of a constitutional violation. And the briefing, by Mr. Desper itself does not establish that a failure to provide notification of the results of the committee's decision, that in and of itself rises to a level of a constitutional violation. The parties here agree that Overton sets a standard of rational basis review. And I think the place that my friend on the other side departs from Overton is that rather than apply the rational basis standard set forth in Overton, Mr. Desper asks this court to evaluate whether the regulation is rational as it applies to him. And he does not argue that is premised exclusively on a failure to provide notification. His view of rational basis isn't an accurate representation of how rational basis works, because by its very nature, rational basis review looks at a policy as a whole and the general justification for that policy. So an argument that a policy is not rational as it applies to a single person.
I don't think that argument is being made. You're shooting at a straw man.
Well, but I think that's how rational basis works, Your Honor. It's a challenge to the policy as a whole. And the argument raised here that the policy is not rational as applied to a single person, that's an argument that the policy is over-inclusive. But evaluating whether a policy is over or under-inclusive is a question of strict scrutiny, not rational basis review. Inherent in permitting policies to not be perfectly tailored, that is, in allowing them to be somewhat over-inclusive or under-inclusive, as is the case with rational basis review, means that at times a policy will apply to some people for whom the policy is not a perfect fit. That does not make the policy arbitrary, nor does it mean that the policy fails rational review. And of course, all of this assumes that there is a constitutionally protected interest in the first place. Far from holding that incarcerated people have a constitutionally protected interest in in-person visitation, this court has suggested the opposite in White v. Keller, in Oxidine v. Williams, and in Williams v. Osmond. And to be clear, this case is about in-person visitation, not about video visitation. There is a separate program laid out in the operating procedures for video visitations, but it is a different program, and that's available at JA 49. Nowhere does Mr. Desper allege that he applied for and was denied video visitation under that separate program. If he applies under that program for video visitation and he's denied video visitation, he can certainly contest that, but that is not this case. This case is about in-person visitation. To rule in Mr. Desper's favor, this court would have to make two exceptional leaps. It would have to recognize a right that neither this court nor the Supreme Court has ever recognized, a right to in-person visitation for someone who's incarcerated. And second, it would have to conclude that a policy fails rational basis review simply because it is over-inclusive as to one person. But that is not rational basis review. All of this is notwithstanding the numerous other states with similar policies that have been upheld. Neither of these leaps Mr. Desper asks this court to make is supported by the law. The district court therefore properly held that Mr. Desper failed to state a claim. And unless the court has any additional questions, we ask that this court affirm. Thank you.
Thank you, Ms. Collin. All right, Ms. Khan, you have some rebuttal?
Yes, Your Honor. Your Honor, I have 3 brief points on rebuttal. First, opposing counsel is wrong to suggest that courts haven't recognized a claim like Mr. Desper's. Second, opposing counsel inverses the 12b6 standard. And third, opposing counsel conflates the as-applied and facial challenge. First, Your Honor, the Supreme Court clearly laid out in Overton that visitation restrictions should be evaluated in the 4-part Turner test, and it found that those particular regulations were valid. It did not hold anything about visitation restrictions as a matter of law. Instead, the decision reflected that our visitation restrictions that are applied arbitrarily or permanently present a different challenge. And Mr. Desper's case picks up where Overton left off. As this court's sister circuits have recognized, most recently in Easterling v. Thurmer, the 7th Circuit found itself to be joining the weight of authority in interpreting Overton to find that an incarcerated parent, even one with a history of sex offenses, states a plausible claim when he alleges that prison officials have arbitrarily and indefinitely denied visitation with his minor child. Ms. Collin is right that the policy balances the interests of the prisoners, the visitors' safety, but the policy isn't being challenged. She's only defended the state's reasons for implementing this policy, but hasn't explained any reason as to why it was applied to Mr. Desper the way that it was. And moreover, prison officials have to exercise their judgment in order for the court to defer it. On this record, we don't have an exercise of any prison official's judgment. The state can submit all of this information on a motion for summary judgment, and the district court can take a look at the full factual development of the case and make a decision about the scope of Mr. Desper's right and whether infringement was made. But on this record, that's simply not possible. And to deny Mr. Desper's claim here would be to suggest that no incarcerated parent in any circumstances, no matter how arbitrary the prison's denial of visitation is, can challenge visitation. Moreover, whether or not video visitation would satisfy the state's interest and accommodate Mr. Desper's parent-child relationship is another question that is suited for summary judgment. Ms. Collin says it's a separate program, but Mr. Desper is suing for injunctive relief of an ongoing ban. We have no reason as to why video visitation wouldn't work here, why that can't be a plausible alternative. This court in other First Amendment contests, for example, in Jehovah v. Clark, has found that a prisoner made it past a 12b6 motion when there was a suggestion of an arbitrary application and there was a clearly reasonable alternative that could be inferred based on the complaint. And that brings me to my second point, that the 12b6 standard requires that inferences be made in Mr. Desper's favor, not the state's. So anything that is suggested in his complaint needs to be interpreted in his favor. The state can't now inverse the standard and say that there's plausible reasons why they might have denied him visitation. Mr. Desper deserves that inference on this limited record, and we have no information as to what decision the committee made, why they chose that, and what changed after 6 years of giving visitation in that same system that prison officials facilitated, that Mr. Desper all of a sudden could have visitation.
On that question, I thought it was the enactment or adoption of the regulation that was then applied. In other words, before, I don't think there was a regulation, was there?
There wasn't, Your Honor.
Yeah, so I think the explanation for why there was a change was the enactment of the regulation.
Your Honor, the timeline doesn't match that. The regulation went into effect in March 2014. It wasn't until almost 2 years later that visitation was restricted. Under those 2 years, prison officials knew that this policy existed. Mr. Desper was still regularly visiting with his daughter. There was no mention that visitation wasn't safe or that there was some reason that visitation wasn't appropriate until all of a sudden one day she's no longer on his visitors list. That suggests a plausible, arbitrary denial of visitation. And since then, the state's continued to deny visitation. And no matter how many times he's reached out or tried to better position himself to be able to get visitation, they haven't provided any opportunity. Your Honor, lastly, Ms. Callan conflates the as applied and facial challenge of the regulation. The Supreme Court has made clear that an as applied Turner analysis is appropriate. Your Honor, I see that my time has expired. May I briefly conclude?
Sure.
Your Honor, I would direct this court to the Sixth Circuit's decision in Flanagan v. Wilkinson, where on note 5, it clearly notes that the Supreme Court precedent makes clear that as applied Turner challenges are appropriate. And for those reasons, we ask you to recognize Mr. Desper's as applied Turner challenge and reverse the district court's dismissal of his complaint. Thank you.
Thank you, Ms. Khan. First of all, I want to recognize Ms. Hashimoto's appointment. You know, that's enormously important for us to have counsel representing defendants, and that's an important role. Appreciate it very much. And especially in this case where we've gotten an expert advocate. Are you a third year now? 3L?
Yes, Your Honor.
And you're so you're going to come back here next year as a fully blown lawyer and argue further cases before us? You're welcome.
Keep our fingers crossed. Thank you, Your Honor.
Anyway, we have a tradition where we come off the bench and we shake hands to all of you, and we can't carry that out, but we want to do that virtually here with you and recognize your arguments on both sides, and thank you for them. Thank you for your service, and you did a fine job. I think you're on the way to a big career. Thank you. And we'll, Judge Rushing and Judge Floyd, do we need a break or should we go on?
I'm all right, but I'm not opposed.
All right, Ms. Maluchik, is it Maluchik?
Maluknik, Your Honor.
Maluknik, excuse me. So I can hear you. Mr. Bamberg, can you hear me?
Yes, Your Honor, I can hear you loud and clear.
Okay, good. So we'll hear the next case of Amgard Insurance Company versus S.G. Patel and Sons. And Ms. Maluknik, we'll hear from you first.
May it please the court. Crystal Maluknik, counsel for appellant Amgard Insurance Company. There are two issues before the court in this action for interpleader and the nature of interpleader and for declaratory judgment. First, whether the district court erred as a matter of law by granting the motion to dismiss of certain defendants and not considering the citizenship of Amgard, the stakeholder who had pursued a complaint in the nature of interpleader, in determining whether minimal diversity had been satisfied for purposes of 28 U.S.C. 1335.
Let me ask you just some foundational fact in this. Did the court actually address your motion, or did the court sua sponte just dismiss the case for lack of diversity?
There was a motion to dismiss that was filed, Your Honor. The court granted the motion, but did so on grounds that were not raised in the motion.
So what was the court's specific conclusion?
The court concluded it did not have jurisdiction because there was not minimal diversity present, because it could not consider the citizenship of AmGuard, the plaintiff and stakeholder.
All right, and that was based on the 1335, where there has to be minimal diversity among the claimants.
Yes, Your Honor.
And how did the court address the 1332?
The court did not address 1332 at all in its decision. The court recognized that it had the ability to convert the statutory interpleader to one as rule interpleader under Rule 22, but it did not do so, and it did not address the declaratory judgment aspect of the case, although it had jurisdiction to do so under 1332 and 2201.
That being the case, ma'am, at your last statement, how do we have jurisdiction then if she didn't rule on the declaratory judgment issue?
Well, the court dismissed the complaint outright, finding it did not have jurisdiction under the interpleader statute for 1335, but did not address any of the other components of the complaint.
Did anybody argue the distinction between an interpleader and a case in the nature of an interpleader?
The specific issue was raised at argument, but the court did not disclose at argument that it had questions as to its jurisdiction and as to whether it could consider the citizenship of AmGuard. In making its ruling and issuing its order, it did note in a footnote that when there is a nature of interpleader, that the stakeholder citizenship could be considered, but held that AmGuard had not made such a claim despite the clear statements despite the clear allegations in its complaint on a specific count for complaint in the nature of interpleader and count 2 of its complaint.
And how did the court handle the declaratory judgment claim?
It did not. It simply held it did not have subject matter jurisdiction under 1335 and did not address any of the issues under 1332.
All right.
So our first issue is whether the citizenship of AmGuard should have been considered under 1335 for purposes of statutory interpleader. And secondly, our alternative issue, which the court has already touched on, whether the district court abused its discretion when it dismissed the case entirely instead of converting it to rule interpleader when it had jurisdiction to do so, or to entertain the complaint for declaratory judgment, or to allow AmGuard an opportunity to address these issues or amend its complaint. Turning to the first issue, dismissal was not proper here because minimal diversity was present as to vest the court with jurisdiction under 28 USC 1335. The interpleader statute gives the district court original jurisdiction of interpleader actions or in the nature of interpleader, which is present when the stakeholder themselves has an interest in the stake at issue before the court. AmGuard here had pled its own interest in the stake in the issues before the court due to the dispute over the limits of liability and the other issues that had been presented, and therefore its citizenship should have been considered as a claimant as to give rise to minimal diversity and vest jurisdiction before the district court. This is the decision that's been followed by the Fifth Circuit in the Loomis Court, and was an issue that the district court raised sua sponte as the sole argument by the defendants in moving Smith was an issue as to ripeness. The defendants, as they have argued here, argued that because they had withdrawn their Tiger River time-sensitive demand, the issues before the court were not ripe.
Well, the court didn't rule on that.
Correct, Your Honor.
Okay.
Can I ask you, counsel, about the Roche case, where it's the American Family versus Roche, where the court analyzes the question whether an insurance company is an interested stakeholder separately from whether they are a claimant, and concludes that yes, they could be an interested stakeholder because they, if the company is disputing liability to one of the, or disputing that one of the claimants is entitled to the insurance proceeds, but concluded that in a case like this, the insurer is not a claimant because they're not claiming a piece of the pie. They've put their own money in reserve, and then are, in that sense, they're only claiming that they want their own money back. That in that sense, the interested stakeholder is different from the claimant for purposes of 1335. I take it you disagree with that analysis, but where's the flaw in that?
Yes, Your Honor, we do disagree with the Roche analysis. I believe the court erred in Roche as it essentially rewrote the statute. The statute speaks in terms of claimants as to all claimants to the funds and the stake at issue. The Roche court looked at claimants in considering who was making a claim under the policy, and focused in on using that term to define claimant, when courts interpreting the nature of interpleader have held that anybody, including the stakeholder who has an interest in the stake, is considered a claimant. I think that the Roche decision was also contrary to what the Supreme Court had recognized in Tashire, that in a nature of interpleader case, that the insurance company was a claimant, its citizenship could be considered. But I think that the Roche court went contrary to the plain language of 1335 in making its determination.
Well, the argument, you also have the argument, I suppose, that a stakeholder by definition is somebody that's just a new stakeholder, challenges the money and doesn't want to give it up. In the nature of an interpleader, it's no longer just a stakeholder. It's also a claimant. I think that's your argument, isn't it?
Yes, it is, Your Honor. Said much more artfully than I have this morning, but that's exactly our position. When you have an interested plaintiff who is more than just a disinterested stakeholder who is interpleading their money into court, they thereby become a claimant whose citizenship can be considered by the court in determining whether there is minimal diversity amongst the claimants. The statute does not speak in terms of diversity, minimal diversity just amongst the defendants. It uses the term claimants, and as a plaintiff pursuing the interpleader, they are therefore a claimant as well. Yes, Your Honor.
Why is the federal forum necessary in an instance like that? If the only diverse claimant is the interested stakeholder, then it would seem that you could have service in a state that, and use state interpleader, where if all the other claimants are in, citizens of the same state. Why is the federal forum, necessary?
The federal forum and the protections afforded by the interpleader statute give you additional protections that the state interpleader do not have. You have the injunction statute that attends to the statutory interpleader in federal court, and it allows you to join everyone in one forum where you may not have appropriate venue in the state court.
But here you would, right? Because the claimants are all citizens of the same state and they're all in the same area.
Yes, you would, Your Honor.
Anything further?
Just as to our second issue, alternatively, if if AmGuard citizenship should not have been considered, then the district court abused its discretion in not at least converting this case to one under Rule Interpleader under Rule 22, as we do have complete
I don't
diversity.
understand why you have to convert. Rules don't have to be invoked in complaints. Rules guide a process, and it seems to me that your argument has to be that you brought a Section 1332 declaratory judgment action that has been totally ignored. And a court at least has jurisdiction over the declaratory judgment. And in that context, it seems to me that once it determines whether you have to put up $500,000 or $3 million, then it can require the defendants to interplead among themselves under Rule 22. But it seems to me there's no invocation or conversion. There's no cause of action under Rule 22. It's just a rule, a procedural rule.
Yes, Your Honor.
All right. All right, we'll hear from Mr. Bamberg.
May it please the court. Thank you, Your Honors. We're of the position that at the end of the day, this appeal is kind of like some country mustard greens and really boils down to nothing. We understand AmGuard's position, but
let me ask you this, just a fundamental question. A party comes into federal court alleging diversity jurisdiction and asserts a declaratory judgment action, and the court throws it out because part of the action is an interpleader, and the court concludes there's no federal jurisdiction under the interpleader. It's incomprehensible. I mean, he just threw the case out.
Well, Your Honor, I think a big point here, and if we look at the procedure of this case, there was a demand made by the parties.
That doesn't have a thing. That doesn't make the controversy go away. The court didn't rely on that. The court basically said that there was no diversity under 1335 and nothing else, and threw the whole case out.
Correct. Well,
no other ruling made.
In part, Your Honor, and AmGuard never alleged that they were a stakeholder at that stage. This
doesn't matter. If they're a stakeholder, they're neutral. It's pure interpleader. And you have to, under 1335, you have to have diversity among the claimants, minimal diversity among the claimants. But in the nature of an interpleader, it's a little bit different. And but that's not what the court relied on. And the insurance company came in and alleged 1332 jurisdiction. And the whole case is before the court, at least under that. There is diversity between AmGuard and the defendants, isn't there?
I don't believe so, Your Honor. I do not believe it.
Why don't you believe so? Where's AmGuard principal place of business?
AmGuard's principal place of business is in Pennsylvania.
And where are the defendants' residences?
Everybody else, as it pertains to the case, are residents of South Carolina.
And is a mountain controversy over the amount, $75,000?
Well, there's not an amount in controversy.
Well, sure there is. There's a dispute between $3 million and $500,000.
Well, that's part of the issue, Your Honor, and this came up in the lower courts. Is at one point there was a dispute. There was a question about how much money was there. AmGuard took the position that their policy was $500,000. Everyone said, "Okay, that's
but let me
fine.
ask you this: you withdrew that letter. If you've withdrawn that letter, can we take it that with the withdrawal of that letter, you are no longer making a claim against the insurance company for any amounts?
No, we have agreed.
Let me just answer my question.
Yes, Your Honor.
With the withdrawal of the claim, can an insurance company conclude that you are no longer going to make a claim against the insurance company for any liability?
Well, we're making a claim against the insured, and
I understand, but you can go against the insurance company. You can ultimately collect against the insurance company once you get a judgment.
Correct, and they have already agreed.
You're not answering my question. Is the withdrawal of your letter a withdrawal of any claim that you have against the insurance company?
No, Your Honor.
I didn't think so, and they didn't think so. That's why they came in for declaratory judgment. It doesn't depend on your letter. It depends on whether there's a controversy. And the controversy is that they are exposed to payment for this accident. And you're going to ultimately try to get that money from the insurance company, regardless of what route you take.
Your Honor, respectfully, I agree with you in part, and I disagree in part. There is no dispute over the amount of insurance at this point. There's no controversy there. They have said there's $500,000. On our side, we have said, okay, that's fine. We still would like to go forward and try these cases. So there's no controversy over the amount. And that is a big differentiating factor here, is what started as a dispute, so to speak, about how much insurance is there. That is what formed the basis for interpleader. That is what formed the basis for a declaratory judgment action to seek the federal court. Hey, there's a disagreement as to how much insurance is available under our policy. We're asking the court to answer that question. Well, that went away when the decision was made. Okay, there's $500,000. That is perfectly fine. At that point, there was no controversy. But I would like to jump back with regards to the subject matter jurisdiction question here. And AmGuard has already acknowledged that the district court can certainly consider issues of subject matter jurisdiction sua sponte. They have admitted that, they have owned that. And what this appeal represents is effectively AmGuard is upset, for lack of better words, that the district court used their ability to consider certain things sua sponte in a way that maybe didn't go in their favor, while at the same time saying the court erred by not using their discretion sua sponte to do something that they wanted. And that's a big problem here. The court noted a couple of good things. Not going to rehash all of that. But at the end of the day, we think the federal court got it correct. There's no controversy. That is why
the rule on controversy, the court ruled on diversity. That's all it ruled on. It said there was no diversity there under 1335. Therefore, we dismiss. Isn't that true?
That is true. That is true. They said they do not have, the court does not have subject matter jurisdiction, and the court does not have subject matter jurisdiction. Based on the specific facts of the case, based on the stance of the insurance company, as long as the interested party and claimants, there's no controversy. AmGuard was not a stakeholder. And more importantly, and I understood the point that was raised earlier about Rule 22, and whether you must plead it, whether or not you don't have to because it's a rule. And we understand that. But at the end of the day, AmGuard was the master of its claim. AmGuard, and I believe the federal court specifically pointed out that AmGuard expressly declined the application of Rule 22 interpleader, and therefore the court used its discretion not to switch this case from a statutory interpleader to a Rule 22 interpleader. And those are two different things. When you look at whether it's a rule that just applies, that's one thing. But as the court noted, AmGuard expressly declined the application of Rule 22 and decided to go with the statute. And under the statutory interpleader, the court, in its discretion, looked at all of the facts and circumstances and reached the opinion that it did not have subject matter jurisdiction. And we agree with them.
Mr. Bamberg, I'm having a little trouble following your argument. You said the $500,000 is fine, but we're going to go on. Well, as a practical matter, the insurance company's not going to turn that money loose unless your client signs a release. And I mean, so what is there to go further with?
All right, Your Honor, a great question. And to answer that, it entails discussing a little bit of the facts of the underlying case that led us here. This is a case about a convenience store that sold alcohol to a bunch of kids. Those kids drank the alcohol. There was a very, very bad wreck in Bamberg County where one of the kids died. One kid effectively became brain dead, broke almost every bone in their body. incurred millions in medical bills. One kid broke their neck. One of the kids, who was the youngest or the next to the youngest of the group at 15, is now facing felony DUI charges. So at this point, this case is not about money. And to the parents who buried their child, the case is not about money. This is about these people having their day in court. This is about a Bamberg County and a Barnwell County, South Carolina jury sending a message to businesses that the lives of children where we live is more important than money. That's why we say the $500,000 is what it is. At the end of the day, when verdicts are had, all of the plaintiffs in the underlying cases are on the same page. There are no bickering between the group. If there's 500,000 and AmGuard, okay, here you go, here's 500,000. We'll handle that at the end of the day. The verdicts are going to be important here, and that is in part a big part of the reason why we made the decision and our clients made the decision. We're not getting in some legal fight over how much insurance coverage this particular gas station has, because this isn't the first time. The underlying store immediately prior to this got busted by the police and SLED for selling to underage kids. They got a second chance and they never fixed the problem. So there's a major public policy issue that's at the heart of this case here. The state of South Carolina, through the General Assembly, it's such a big deal that the state began mandating liquor liability to establishments that sell alcohol by the drink.
Let me ask you this. If you're interested in pursuing that case for much larger than the 500,000, a verdict much larger.
Yes, Your Honor.
Are you willing to release the insurance company from all liability upon payment of the 500,000?
I mean, we have already included in our brief that we're not contesting their assertion.
No, you didn't hear my question. My question was, if they paid you 500,000 now, which you argue would only be part of the damages, because you're arguing the damages are much larger, would you release the insurance company from all liability?
That's something that we could discuss if proffered by AmGuard. But at this point in time, rather than take that route and discuss that, we're here on appeal over.
Well, see, now you're just creating the actual controversy that's creating the right for AmGuard to try to protect itself with a declaratory judgment. I mean, there's potential for excess claims, bad faith claims, and all kinds of things. And they want to have their liability limited to the insurance policy, and that's what they're pursuing. You say it's unnecessary because you have no dispute. 500,000 is all that's there. You want to have a public statement on a big verdict. Well, if you want to do that, the question then is, why don't you let AmGuard out for the 500,000 and give them
we attempted, Your Honor, we attempted that. We said.
I'm asking you now, forget the past.
Yes, Your Honor.
The question is under your argument, there's no controversy now. And I'm suggesting there is a controversy unless you're willing to release them now for 500,000.
Well, that Your Honor, is part of the issue is there at present, there is no controversy. Now will you answer my question, and then I can decide, we can decide whether there's a controversy. But if you say you're unwilling to let the insurance company go, because potentially you may want to make some other argument as to why they owe more than 500,000, then there's a controversy. So the question is, if you want to demonstrate your point that there's no controversy, then you should be willing to accept the 500,000 and give them a full release. And Your Honor, I understand. I promise you, I'm not ducking and dodging your question here. We already expressed to AmGuard before this appeal that we're fine with the 500, that they could go ahead and tender the 500 and let us move forward and get our verdict. So, I mean, we're not creating a controversy in that regard. If they would put that money up and it's held in trust until all these things are done, that's fine.
They didn't even want to hold. They don't want to put it in trust. They want to just pay it to you.
Well, that's what I mean.
As part of the damages for the accident, and you can sue for the remaining part, but you have to release them from all further liability. And you're saying you're not willing to do that.
No, we'd be willing to do that. That's not a problem. And when I say put it in trust, I mean in the trust of the lawyers, not like AmGuard go hold it somewhere. Pay it to plaintiff's counsel, and we'll let it sit or we'll divvy it up however we want to do. And AmGuard just move out the way, defend their person if that's what they're going to do, and let us move forward. And we'll worry about collecting the rest through other means. And unless there are further questions, Your Honor, we don't have anything else to add.
Okay, thank you. Ms. Lukic, did you have a rebuttal?
Just a couple of points, Your Honor, on rebuttal. First, as to there does remain a case or controversy here. Patel, the insured, has contested what the limits are. Their brief, when they filed it, specifically did not include Patel in their statement that they were willing to accept the $500,000 at oral argument or at the hearing on the motions before the district court. The attorney for Patel contested what the limits were. So we still do have a case or controversy here. And as you've seen,
let me ask you this: if after this argument, Mr. Bamberg came to you and said, give me the $500,000, I'll give you a general release, does that end the case?
Only if our insured also signed on to that release.
Why the insured?
Well, because the insured
also has liability beyond the insurance coverage, right?
Correct. No, I mean, as to AmGuard, we obviously owe duties to defend and indemnify as to our insured, and so our insured Patel would need to be a part of that release.
All right, I've interfered enough. You guys know how to handle these things.
I appreciate the court's guidance and inquiries. But we have, as you noted, we have no ruling on what the limits are. The statement that they were in agreement as to the $500,000 came after the court had dismissed our complaint. So we have no ruling on the record. We have no agreement on the record. We have no stipulation. And we've had varying inconsistent positions from our insured as to what their position is, as to what the limits are. We did allege that we were a stakeholder with an interest in the stake in the complaint. It's count 2 of the complaint.
You know, that's the thing I personally believe, and I don't speak for anybody else, that caused the Roche court to get a little off rail, because as I understand the interpleader process, in the nature of an interpleader, it's a 2-step process. The first one is to resolve the dispute that the insurance company has. The claim, the insurance company doesn't want it all or none of it to go. And so you have a resolution on that, and then the money is put in. If the insurance company loses any amount, then that money is put into the pot, and then the claimants interplead among themselves in the second stage. If you had pure interpleader, there would be no dispute about the amount owed. The insurance company would put the policy limits into the court and leave and get an injunction. And that's pure interpleader, and there would then have to be diversity among the claimants. But your argument is, in the nature of an interpleader, the stakeholder also is a claimant. Isn't that it?
Yes, Your Honor, absolutely. If the court has nothing further, I'll...
Okay, thank you very much.
Thank you.
We appreciate it. Our practice, as you probably are aware, we come down, it's unique in the country, I think, to greet counsel after each case, and thank you for your arguments. We can't do that now, but we do thank you for the arguments, and hope you come back to our court again. And the next time you come, we will come down and shake your hands, I'm pretty sure. So thank you very much.
Thank you.
And we'll proceed on to the last case.
Thank you, Your Honors.
A case of Nolesko versus Garland. Mr. Heedy, can you hear me?
Yes, Your Honor.
All right, and Mr. Finn, can you hear me?
Yes, I can, Your Honor. Thank you.
All right, well, why don't we proceed with argument? Mr. Heedy, you're first.
Thank you, Your Honor. Good morning, and may it please the court. My name is Jasmine Tohidi, and I represent the petitioner Herman Nolesko. This case presents the court an opportunity to decide finally whether being a former member of MS-13 or a former member of MS-13 who left for moral reasons is a cognizable social group. In terms of asylum and withholding of removal, the sole issue before this court is whether the group is socially distinct. This court has found that that proposed group is both particular and immutable. I believe that the record compels the finding that the proposed social groups are socially distinct, or alternatively that the immigration judge abused his discretion in mixing the term of social distinction with nexus.
Well, let me try to get to the core of the issue here. I think the immigration judge did have one paragraph where he mixed the particularity language up with distinction, but then the next paragraph seems to suggest otherwise. But on that issue, what is your best evidence in the record that former MS-13 members are recognized as a socially distinct group in El Salvador?
Yes, Your Honor. I believe this court gave a roadmap in Oliva v. Lynch for what
I'm looking for the evidence in this case.
Oh, yes, Your Honor. So first I would say, one, El Salvador has what's called Decree 717, which is a governmental program. Part of that governmental program is to track gang members, and part of the program is to give rehabilitation and re-education programs. That's through the government. There's additionally education and trade programs given by private parties and also the government. And thirdly, the largest group would be evangelical Christians who try to extricate gang members from the gang. So specifically in the evidence, what I'd like the court to look at is 238 to 240 of the administrative record talks about education and trade programs. 268 to 269 is a Voice of America program talking about jail rehabilitation programs to extricate gang members. And then 431 to 433 is an article regarding a gang member who left MS-13. It states that evangelical Christianity is the largest acceptor of people who've left MS-13 and try to rehabilitate them. I believe this court should adopt a precedent that the existence of social and governmental programs is very indicative of the fact that that group is socially distinct.
That gets a little murky because those programs are focused at MS-13 members. And the literature that I read that you attached were stories and conduct against people who had tattoos who thought they were perceived to be MS-13 members, even though they may not have been. And I didn't see anything where people identified as MS-13 members were treated or considered as a group of people at all. They were trying to extricate MS-13. It's a way to treat MS-13 people instead of shooting them, which there's a lot of evidence there that the police were recklessly going about and shooting MS-13 members even without process. These programs you're talking about are alternatives to extricate persons from the MS-13 sphere. But should we treat that as a recognition that there are, in fact, a socially recognized group of MS-13 people that exist in El Salvador?
Yes, Your Honor. I think in two ways. One, I believe vocational programs wouldn't be to extricate individuals. I think it was to reintegrate individuals who already left the gang to allow them to have a means for living. The same thing with religion. I think they serve both purposes, like you said, to rehabilitate and take individuals out, but to also give them a community once they have left MS-13 to be able to continue to not rejoin the gang after that point. And all that it requires is that society perceive that group to be distinct. And that's why I think the threshold isn't as high. I think the immigration judge continuously mixed nexus with a social distinction, stating, well, the tattoos is what makes you visible. But for social distinction, one does not
You
need
can have both. You can have some people that show up visibly and some people that show up non-visibly. There's no question about that. It's a tattoo may be indicative of membership. A person wearing a beard in a certain way, maybe a Hasidic Jew, or a person who's has a turban and wears a beard might be a Sikh. In other words, there are manifestations of groups that are physically manifested, but there are also groups that are not, as you pointed out, gender groups and all kinds of other familial relationships and social relationships.
Correct, Your Honor. So that's why I think I agree with you that some of these programs are to change individuals from gang members to former gang members, but I also think some of these group articles that I pointed out are rehabilitative to continue your path of having stayed out of the gang, particularly the evangelical Christianity, continuing to attend the church, having a sense of community, because one of the reasons individuals tend to go back to gangs, like Mr. Nolasco testified, is a sense of family and a sense of being with a community. So these programs allow them individually to not be in that lifestyle. And I think this is
Ms. Tahiti,
yes.
Is it your position that all former gang members with tattoos can show a substantial risk of torture upon removal to El Salvador? All former gang members.
No, Your Honor, I think you have to look at the nature of the tattoos. And second, I think it's the tattoos, the nature of the tattoos, and the fact that my client was tagged in the United States database as a former gang member. So I think the highly visible nature, there's nothing to say having a large 1 and a 3 on your arm. That's highly indicative of being MS. But there, the tattoo was kind of equivocal. So I think that it goes towards a 51% or greater determination, but it might not be that all individuals with tattoos would meet the CAT. And I think that leads me to one of the largest errors I think the immigration judge made in terms of CAT, Your Honor, which he repeatedly stated twice on the record that if I grant this case, then I must grant all former gang member cases with tattoos. However, the regulations require the immigration judge to assess an individualized risk of torture, and the immigration judge should have never considered the scope of his ruling and how it would impact other individuals. In this case, if the court were to find that the group were socially distinct, the court would have to remand proceedings back to the Board of Immigration Appeals because the issue of nexus was not determined. But I think that this court has been grappling with the issue of whether former gang members are a cognizable social group since the issuance of Martinez. And immigration judges have been very reticent to find that group is socially distinct or particular. But I think that it's very clear that Salvadoran society views the group as distinct because individuals wouldn't create programs and create a sense of community around individuals if they didn't see them as a group separate and apart. I kind of look at it analogous to Alcoholics Anonymous. Although the group is there to keep people from drinking, we view those individuals as former alcoholics. So I would say in the same way, these social groups, yes, they prevent individuals from going back into the gang, but they also keep them separate and keep them from not going into the gang. And in this case, the immigration judge found my client credible, and he did accept that he no longer was a member of MS-13 at that point. The other information, I mentioned it previously, was Decree 717 is a governmental program showing that at least the government itself views former gang membership as socially distinct, because one of the ways you could in theory go out of Decree 717 would be if you had rehabilitated and were no longer part of the gang. Another issue in social distinction that I think the immigration judge made a mistake on is he was overly concerned about whether Mr. Nolasco joined MS-13 in Virginia or El Salvador, but I don't believe Salvadoran society makes such a distinction. And second, it doesn't look at the fact that MS-13 actually originated.
Sorry to interrupt you. I had a question on that point. Was there any evidence in the record about whether a former gang member from Virginia would be perceived as, part of the socially distinct former gang member group in El Salvador. All the evidence I looked at in the record seemed to be about how El Salvadorian society views kind of anyone with these tattoos or these markers as a gang member. So even if you're a former gang member, you have trouble, or you're retired, or you're taking a break, you have trouble distinguishing yourself from the gang because society views everyone with these markings as a gang member. I don't recall seeing much about gang members from other places or former gang members from other places, but I wanted to ask you if there was something in the record about that.
Yes, Your Honor. I think, again, that's where Decree 717 comes into play, because that program is specifically targeted towards also tracking deportees who have been deported from the United States. And two, because there's the criminal history information sharing program between the government of the United States and the government of El Salvador that specifically transmits information for individuals who've been deported that have ties to gangs, that shows that Salvadoran society in large doesn't care about the origin stories of where the individual joined the gang. And like I stated, MS-13 actually originated from the United States. And
that doesn't have to do with it's not just former gang members, right? That's the reason that these databases and these tracking systems are in place, is because of gang membership and gang ties. So what is there that's distinct in the evidence that shows that former gang members are a distinct group, rather than, they're trying to distinguish themselves from members of the gang, but the evidence that I looked at seemed to suggest that that's a difficult thing to do in El Salvadorian society.
So I think that goes towards whether an individual would trust that you've actually left the gang. But again, as I said previously, I think, for instance, vocational programs, teaching people who've left the gangs to get new jobs, to find new ways to make income, is indicative that we see them as former and distinct. The same thing with Christianity, attending church. At a certain point, continuing to go to church over time, again, shows a commitment that you're a former member. So I do understand in some of these programs, it's a rehabilitative to change someone from a current gang member to a former gang member, but the vocational and trade programs are geared towards individuals who have been identified as former members of MS-13. Additionally, like I stated in the article in The Intercept, the individual was a former gang member, and the police didn't believe that he actually had left the gang, and stated individuals like you use Christianity as a way to fool us. But I think that still shows that society views former gang members as distinct. Whether or not they believe that you are a former member, I don't think goes towards the issue of social distinction. I think that would go towards an issue of nexus. Would I persecute you on account of the fact that I think you're former, or because I believe you're a current gang member, Your Honor? I'm sorry, I didn't mean to interrupt if Your Honor had another question.
Oh, no.
Okay, and then, Your Honor, I would like to briefly touch on Convention Against Torture in this case. I believe the record had ample evidence that Mr. Nolasco would be tortured in this case. The country condition report specifically references the murder of suspected gang members. This case is separate and distinct from Singh v. Holder or Swarens Valenzuela. In Singh v. Holder, this court found the mere existence of human rights violations can't carry the burden for CAT because you couldn't look at generalized conditions. In this case, the record had ample evidence that individuals who were suspected gang members were tortured by governmental forces. The immigration judge didn't give reasoning as to why, looking at all the factors and considering Rodriguez Arias v. Whitaker, that he couldn't meet his burden. Specifically, the Department of State references on 202 and 204 the killing of suspected gang members. It was actually in the executive summary of that report, which states that it's one of the most important things that they're looking at. Additionally, El Salvador decided to omit homicide data of when the police have a shooting or kill gang members, and that was at 335. So I think too, it shows that the government has a propensity of torturing gang members if they no longer want to account for the information of how many individuals were actually killed by police forces. There was the article by CNN at 422 to 433, which stated that there was a group of police officers who were murdering individuals suspected of being gang members. When they were found out, instead of firing those police officers, they reassigned them to a new police unit. So I think the way that they would find out that Mr. Nolasco is a gang member is one, his tattoos and the transmission of that evidence, and that MS-13 will kill him for believing that he won't rejoin the gang. 18th Street would try to kill him because he's a rival gang member, and the police would try to kill him because that's how they're dealing with individuals who are suspected gang members in El Salvador. So I think he's amply met his 51% or greater chance, and the immigration judge was overly concerned with the scope of his decision and tattooage versus the facts of this case. And Your Honors, I'm almost out of time unless somebody has another question.
Is it a legitimate concern under any of the analysis which you've laid out to worry about the fact that with applying the analysis as you've set it forth would require us to retain every MS-13 member, whether he's a current member or an ex-member? In other words, we could never deport an MS-13 member because as part of the condition of being a member, you get these tattoos. And having the tattoos, it identifies you as a former member, and as you know, MS-13 criminal history is particularly vicious. We get lots of cases up here on MS-13, and they are very, very difficult criminal cases. So the question I have, is it a legitimate concern under any of these analyses to whether every MS-13 person would then get harbor in the United States? In other words, we could, under what you're saying, we could never deport another MS-13 person to El Salvador.
No, Your Honor. So I think, again, for like risk of torture, it has to be an individualized risk. So one,
but the risk you're identifying is individualized to every MS-13 person, whether existing a member or or an ex-member. Because the reason that he's treated that way in El Salvador is because people see they pull up the shirt and they see the tattoo and they shoot him. Or they see he's got a MS-13 gang and it's another gang kills him. That's your argument. And the question is, doesn't that apply to every MS-13 person in the United States?
So, Your Honor, I would say no. One, the tattooage that my client has is highly specific to MS-13. So I would, one, look at Quinteros, where you had a tattoo that required an expert.
I understand that's a possibility, but I'm going to tell you, almost everybody gets a tattoo that identifies themselves with MS-13. Now, if that didn't happen in that one case, that's an exception. But the whole purpose of the tattoo is to identify the person with the gang and to make a commitment to the gang that's permanent. And he's told he cannot leave the gang. And if he does, the gang leader gives the green light and any member then can shoot him. And that happens in the Baltimore, Washington area, Long Island area, Los Angeles. I mean, there's these centers where MS-13 is pretty well organized. And I wonder, my question to you remains is, if we were to conclude that your analysis would require us to harbor every MS-13 person based on the fact that that person has an identifiable tattoo linking them to MS-13, is it legitimate for us to be concerned that we could never deport an MS-13 member?
I think, Your Honor, the country conditions make it so that I believe former members of MS-13 have a more likely chance to have a CAT claim than I would say other Salvadoran individuals, but I would still go towards the fact that it's very individualized on how visible is this individual as a member of MS-13, what's going on with the current Salvadoran government, and two, not all individuals who have been associated with MS-13 have arrests and convictions for street gang participation like my client does. So as you've noted, MS-13 too has different kinds of hierarchy. So I think in this case, my client is more likely based on his individualized facts and to the current
but
government.
none of those facts come into your analysis. We don't look at whether he's got a criminal record here. We're deporting him for whatever reason we're deporting him. But my point is the individualized analysis that you're calling for, there's nothing that under that analysis that distinguishes an MS-13 person who has an identifiable tattoo or tattoos, usually it's multiple tattoos linking them with MS-13. I say that's the problem, but what you're saying is there is an answer because it's individualized, but I'm trying to say the analysis you offered is not individualized, it's systemic.
Correct. So if Your Honor's concerned about the scope of it, still I think remand would be appropriate because the immigration judge abused his discretion by repeatedly making the statements in this case of stating, if I grant this case, I must grant all MS-13 former gang member cases rather than looking at it.
And my question is that illegitimate?
I believe the scope could be broader, yes, Your Honor, but I think you have to look at the individual, what
So
their
we're not
risk
allowed to
factors are.
consider that either then. In our review of your case, we're not allowed to analyze or be concerned about the fact that it's going to have a universal effect.
Because I don't believe it would have a universal effect, Your Honor, respectfully.
What if we concluded it would?
I mean, immigration practitioners would be happy with that, but I don't think that it requires that under CAT because you have to look at each individual's circumstances. And two, the government of El Salvador can always change and stop tracking and murdering people that they view to be former members of MS-13. So even for a short period of time, if it was more likely than not that some of these individuals will be targeted, doesn't mean that forever in time that they would be entitled to relief, Your Honor.
Okay, thank you. Mr. Finn?
Yes, thank you, Your Honor. I'll start at that point of the discussion, which is essentially the Ortega case. Okay, in the immigration judge's decision, he directly referred to the Ortega case and said, this is non-controlling, but he appreciated the analysis in the Ortega case. When we get to the board similarly cites in a compare site the Ortega case and cases from the Sixth Circuit and the First Circuit. Neither the board or the immigration judge cited those cases as controlling. What they did was the factual analysis required to determine whether the petitioner had proposed a particular social group that was in fact socially distinct, which is a question, a mixed question of law and fact. So unlike the question of particularity or immutability, which may be definitional and therefore purely legal questions, social distinction requires showing a factual basis upon which to apply the legal standard. And I think at that point, I would also note that what this case also brings into play is the issue that the petitioner's counsel here has noticed that, like in Alcoholics Anonymous, there's a question of how do we define this group? How is this group perceived socially? And if I remember correctly, even people who are in Alcoholics Anonymous, who are being, are moving along and are no longer having a significant problem, still go to meetings and admit at the beginning, I'm an alcoholic. So this question of what is a gang member and a former gang member on this record is not clear, because the Intercept article, which was the primary document that was being argued before the immigration judge, the Intercept article is of itself confusing. The subject of the article attempts to lead the gang, knows that he can't lead the gang in a sense. The gang he asks to lead, but he gets pulled right back in. How does that demonstrate that El Salvadoran society sees him to be either a gang member or a former gang member? It does not. It definitely shows that the gang doesn't make such a great distinction. They may have a formal process that was described in the article about how someone distances themselves from the gang, but they also have a process to bring people back in. And that's the question. Even here, it's not clear because we're looking at the question of social distinction from the perception of the persecutor, the gang itself. So, the case law is clear on that. I believe MEVG or WGR discuss very specifically the problems of seeing a distinct social group from the perspective of the persecutor. The evidence in this record does not support a finding that a former gang member is a category or a group of people that are discrete in a significant way in El Salvadoran society. The record makes many references to ex-members, people that are in different positions as to their relationship to the gang, but it does not make a clear distinction about what the society sees. To the extent there's reference to the evangelicals, the evangelical community, I should say, in El Salvador, the Intercept article makes clear that this particular subject of the article aligned with an evangelical community. They knew of his past, and he had a mentor. What it does not show is that the entire evangelical community makes a distinction between former and active gang membership. All it says is that in this one instance, as proof that for this case here, I guess, in this one instance, they were willing to work with this person to bring him into their evangelical community and help him improve his life. But again, he went back to the gang eventually. Former membership really is a difficult and strained concept. Much of the argument before the immigration judge did center on this question of the tattoos, the visibility of the tattoos. And so I think as we read the immigration judge's decision, and he starts in his discussion of social distinction, and he moves to the question of the tattoos, I think that has to be read in light of the record transcript itself and of the arguments made in the closing portions of the hearing. Because the fact that he had these tattoos that evidence his membership to MS-13 was really integral to his case. There wasn't really a sense that if he didn't have tattoos and he returned to El Salvador as a former gang member, he was in any danger. The membership, as Judge Niemeyer pointed out, these are essentially marks put on the gang member by the gang to affiliate that person with the gang for life. And as such, if the immigration judge discussed the tattoos in that context, I think he was reacting to very much the presentation that he had had before him at the merits hearing, to include having the petitioner stand up and reveal his tattoos, and significant discussion during the course of argument by both petitioner's counsel and the DHS counsel about what the meaning of the tattoos was. I do believe for the context we have here today, though, the tattoos have much more bearing on the question of Cat, because in fact, that is a reasonable consideration in terms of his future likelihood of torture. But I don't think was improper for the immigration judge to divert his discussion on social distinction, because that very much reflects what was going on in the merits hearing. And I think he was trying to make sure he was complete in his consideration of the content of the subjects that were addressed to him at that hearing. I've already discussed the Intercept article. I would also note there was a discussion of an article I will call the Florida International University study, which was submitted by the DHS, which was a survey of gang membership. And Petitioner's counsel referred to that in her briefs. I would note that the Florida International University study can be found at Joint Appendix page 292. That study was a survey of gang members and former gang members, but the study itself doesn't define what it means by a former gang member. So we're now in the same position of we're looking at this case from the perspective not of El Salvadoran society, but of gang members themselves. And even in that article, it confuses and discusses multiple standards, just different positions gang members can be in relation to the gang. It's not simply gang member, former gang member. I would propose that, as I said in my brief, that gang membership from the perspective of the society is not so discreetly broken down. Gang members are gang members. That's what the record seems to support. I would note on this question of Decree 717 that is a decree, and this was addressed by the DHS counsel in her closing argument as well before the immigration judge, that applies to dangerousness. And it's not such a simple statement of they're going to necessarily have human rights abuses that relate to Decree 717 or other rehabilitation efforts for deportees or returning. The Kirkland article, which is at Joint Appendix 417, seems to just suggest that, in fact, human rights abuses occur directly because of Decree 717 or the return of deportees. But as DHS counsel pointed out in her closing argument, the footnote cited in that study in the Kirkland article does not support whatsoever the assertion of human rights abuses directly related to Decree 717 or the return of deportees via information sharing from the United States. In fact, the materials from the Department of State, the materials from ICE that are in the record indicate that the American side of that equation, or I should say the United States side of that equation, take human rights abuses and conditions in El Salvador quite seriously, even for those people they're returning. However, it also recognizes the dangerousness of returning gang members into their society. After all, these are part of a larger criminal enterprise. As for the issue of El Salvadorans, how they perceive persons who are not from El Salvador in terms of their gang membership. As Judge Rushing was asking her questions, I remembered that the issue really is not whether there was a specific way of identifying, but there's an absence of proof here. There's an absence of proof that petitioner would, in fact, under the circumstances, facts provided in this case, be in fact seen as a former gang member in El Salvador. We don't know. It's just an absence of proof. And therefore, I think in that situation, as we talked about earlier, the social distinction requirement is both a factual and a legal inquiry. An absence of proof goes to a problem in their presentation of the evidence, and they have not supported their assertion that former gang member is a cognizable group with respect to the issue of social distinction. I would note that it's not surprising, and before I turn to Kat, it's not surprising that there's always skepticism or difficulty before both the immigration judge and the board, and here with the idea that membership in a gang could create a refugee status for a person. But PSG analysis is, for purposes of social distinction, is a factual analysis. And in this case, our argument is not broad. It is, this record does not support a finding the petitioner established his particular social group, because the facts to support social distinction are absent. Unless there are questions on the social distinction argument, I will move forward into the CAT question. There are really two issues here, and that is whether the record, the decision of the immigration judge and the board is supported by substantial evidence, and whether they gave the evidence reasoned consideration. The substantial evidence, I believe, I will say simply that there is very little to no particularized evidence of petitioner's likelihood of future torture in El Salvador. He hasn't been in El Salvador for 25 years. He's not traveled there. His entire gang membership has been in Virginia in the MS-13 gang. To the extent there's a question of substantial evidence, I would note that the immigration judge had quite a bit of evidence before him, not only from Petitioner's Counsel, but from the Department of Homeland Security. They submitted a robust package of rebuttal evidence that DHS Counsel on the record clarified for the immigration judge. We submitted evidence that post-dated Rodriguez arrest, specifically because we wanted to be current and rebut the type of information that supported the petitioner in Rodriguez arrest. In other words, the DHS did its job here. And so substantial evidence and the question of whether this record would compel a reasonable fact finder to find to the contrary, I don't believe has been made out, nor can it be made out on this record. The record very much supports the finding that there has not been a showing the petitioner himself is subject to future torture, a likelihood of future torture upon his return to El Salvador. And the last comments I'll make on the CAT is the question of reasoned consideration. And here, the immigration judge did specifically reference petitioner's evidence of country conditions and the Intercept article. The Intercept article was the focal point of the closing argument by Petitioner's Counsel. The immigration judge addressed that article specifically and went on to discuss the country conditions evidence, but was concerned, of course, with the ability of a petitioner to submit just broad amount of country condition evidence with tattoos, and said he was wrestling with that. So I think the question in reasoned consideration is, did he consider it? And first of all, there's a presumption that the immigration judge did consider that evidence. So the proof has to be that he did not. And I believe there is enough in the immigration judge's decision to indicate that. I'll also note that the board specifically referenced the immigration judge's decisions, citing to the factual findings on the CAT claim, specifically at page 5 of the joint appendix. It went through the findings of the immigration judge, that the evidence revealed that there are efforts to combat corruption. There is violence, there is corruption that remains a problem, but that the petitioner himself had not established his CAT claim with sufficient evidence. I don't believe there's anything in the record to indicate that the immigration judge ignored the evidence, which is the basis of the Quinteros case out of the Third Circuit. In that case, it was very clear in the finding in Quinteros, and I would cite there to the record at 787 of the Quinteros case, very clearly there were substantial factual findings ignored by the immigration judge. In fact, they were wrong. The board had in fact found that had not shown he was likely to be identified. We've made no argument here that the petitioner wouldn't be identified by gang tattoos, or that he would be discovered because he can be covered. The immigration judge pushed that you can cover tattoos, but he never said that that negates or would not support his claim. So unless there are any additional questions, that concludes my argument today.
Okay, thank you, Mr. Finn. Ms. Tejeda? I think you're muted. Can you hear me?
Yes, Your Honor, I apologize. So I just wanted to follow up on two brief points. One, Ortega in the Ninth Circuit was actually found not credible. And two, this court characterized it in Martinez as stating that Mr. Ortega was actually a current gang member, not that he was a former member of MS-13. So I think that case one is inapplicable here as precedent because one, it looks like this court has rejected it in Martinez and it deals with active gang members rather than individuals who have left. Also, respondent has brought up, how do you know who's a former gang member, who's a current one? I think that goes towards the question of particularity, which they have conceded. I don't think Salvadoran society as interested on whether you're retired or former. And again, I would just go back to the fact that the country conditions show that the society views this as a distinct group set apart from the population as a whole. And then in terms of CAT, the immigration judge stated, yes, country conditions are improving, but did not look at the fact that are they improving for this disfavored group of former gang members. So a country might be making strides in other areas, but may still persecute certain individuals. For instance, there are certain countries, let's say Sierra Leone, which may persecute people who are gay, but wouldn't persecute the population as a whole. So I would say the same thing kind of goes for a CAT for Salvadorans, which is the government may be making strides to improve its judiciary, things like that, but they aren't improving the corruption of killing former gang members. The 2017 and the 2018 report both showed that the murder of gang members is still a problem within El Salvador, showing that they haven't been improving. And the
So just to clarify, you said the murder of gang members, and I think you're right. That is what the evidence shows. But what is the evidence about former gang members as a discrete group who are targeted for torture?
So I believe for purposes of CAT, it doesn't matter whether you're viewed as former or current. So all that matters is you're targeted, because I don't have to show a nexus to a protected ground. So in that case, it doesn't matter that the government views them as a current gang member or distrusts their word that they have left the gang. So that's
it's the same evidence, right? That you're using the same evidence for both the CAT and the asylum claim.
That's the same evidence, I would say, but in this case, this court can't come to the issue of nexus or whether there's a well-founded fear, because the board didn't address that. So the only issue in terms of asylum is just whether or not that group is distinct. And I think looking at the country conditions in totality and his testimony, that he's met just the fact that society sees it as socially distinct. And secondarily, I think he's met his burden for CAT. And even if that means that several gang members or former gang members are granted CAT, that doesn't negate the fact that they can meet the 51% or greater risk of torture. And the United States has other means to track those individuals. Additionally, with CAT, you can send someone to a third country, or you can come back to court if country conditions change and try to remove that individual. So being concerned about the scope, I think, goes contrary to the Convention Against Torture. And if your honors don't have any more questions, I'd like to rest on my brief.
Thank you. Thank you. Appreciate the arguments. Our practice is to come down and shake your hand. And thank you for your arguments. And if either of you have been before our court before, you recognize that is, I think, a nice touch. And we'd love to do that now. We can't. So we're doing it virtually, and thanking you for your arguments, and hope you come before us again. And at that time, we will shake your hand and talk to you about baseball or whatever you want.
Thank you, Your Honor.
Thank you, Your Honor.
All right. So with that, we'll stand adjourned. Thank you very much.